Invite my lord's kind attention to the statement of objections in which certain serious allegations are made against the petitioner. May I request your lordship to kindly turn to paragraph.
Allegations against the petitioner.
Yes, my lord. Kindly turn to paragraph 19. Now I shall demonstrate the encomiums that are given to the Central Bureau of Investigation by the trial court in a couple of seconds. Who has been protracting the proceedings? Why the proceedings are being protracted? Kindly turn to paragraph 19 for a second. That is the last paragraph, my lord. It is submitted that the conduct of the petitioner in approaching this honorable court at a belated stage, after a delay of almost 15 days since the passing of the impugned order, is only a thwarted attempt to delay the trial. The purpose of criminal trial is to unearth the truth, and it is a journey or a voyage towards discovery of the truth, which is the ultimate object. The petitioners have made all the attempts at their disposal to delay the culmination of the trial in spite of this honorable court's direction to conclude the trial expeditiously, preferably within a period of 3 months. May I request your lordship, may I just pass on to your lordship the proceeding sheet of the case in which your lordship would find the encomiums that are given to the prosecution by the learned trial judge, who has been protracting the proceedings, for what reason, for what purpose the proceedings are being protracted. Your lordship would see. May I request your lordship to kindly turn to the proceeding sheet dated 21/10/2020. Your lordship kindly turn to 15/11/2024. Well, let me submit your lordship what transpired on 14/11/2024. Lordship, would your lordship kindly go to the proceeding sheet of the case dated 15/11/2024. On that day,
Is
Yeah.
given pardon.
a person by name Shivananda Srishaila Biradar, who came to be treated as an approver in the case, was present before the court.
ಬಸವರಾಜ್ ಮುಟ್ಟಗಿ ಅಂತಿದೆ.
ಅದು ಅವನ್ ಬೇರೆ. ಇಲ್ಲಿ 15/11 kindly go to
ಯಾವ್ದ್ರಲ್ಲಿ
page 309
ಮೇನ್ ಪಿಟಿಷನ್
proceeding sheet.
ಈ ಕೊಟ್ಟಿದ್ದು
ಹೌದು, ಈ ಕೊಟ್ಟರು.
1511 case called out, accused number 1 Baswaraj Muttagi is given pardon, SPP is present, office is hereby directed so and so.
Next, ಅದರ next bottom ಅಲ್ಲಿ ಪುನಃ 15/11.
Approver by name Shivananda Sri Shaila Biradar.
Kindly go to the next page, kindly go to the next.
Yes,
Case
sir.
called again. Approver by name Shivananda Sri Shaila Biradar is present before the court, and he is examined as PW9 and fully cross-examined for further trial by 16/11/2024. On 15, in the later part of 15/11/2024, this A9 who was given the pardon, benefit of pardon, and who came to be examined as a witness on behalf of the prosecution, he having not chosen to toe the line suggested to him by the prosecution, came to be treated hostile by the prosecution, and he was cross-examined by the prosecution and thereafter by the defense. But he came to be examined by the prosecution with regard to the charge that is framed against the accused for an offense which is made penal under the provisions of the Arms Act. But then the trial was adjourned to 16/11/2024, on which date, my lord, also the prosecution was required to keep 2 other witnesses who would corroborate the statement of the approver. But on 16/11/2024, 2 witnesses were present before the court and they were made to stand outside the court. When the case was called, the prosecution was asked whether the witnesses who are summoned for the day are present or not. The prosecution would say that we have no idea or we have no information about their presence before the court. My lord, their names were called. They appeared before the court saying that we are so and so. Now kindly read this 16/11/2024.
Yes.
My lord gets it, my lord? CWs 56 and 57 are present before the court and they are discharged. Why they are discharged? My lord, on 15/11/2024, the public prosecutor will examine that approver. He would even cross-examine him. The defense also would cross-examine him. Suddenly, my lord, maybe for, I don't dispute the fact, he would fall sick. The public prosecutor would fall sick on 15/11/2024 at a point of time when CWs 56 and 57 were present before the court. I am not disputing, my lord, for a moment the fact of he having fallen sick. But what the defense would submit to the court is, at least you should have kept us informed that he is likely to fall sick when 56 and 57 are before the court, for one reason or the other. That was our grievance. Now kindly read the encomiums which the court would give.
Yes, I've seen.
It is rather unfortunate to note that in spite of providing sufficient opportunities, the prosecution are unable to furnish appropriate details of the witness they are intending to examine. Repeatedly, the checkered history of the case indicates that the case was posted for fixing the date of trial, and thereafter some witness lists were being filed by the prosecution without ascertaining the list which they had filed earlier. Earlier, they would file one list, but subsequently the entire list gets changed. In the next list, my lord, instead of eyewitnesses, recovery witnesses, punch witnesses, handwriting expert would come into picture now. Doesn't matter. Now kindly read the next paragraph. In other words, there should be some sort of continuity in conducting trial, which unfortunately is found lacking. Though this court had fixed the date of trial continuously, much progress is not being seen, which is causing a lot of inconvenience to the court since the court is unable to take up other cases. Accordingly, the head of Bureau of CBI, not the defense, my lord,
But
the head of Bureau of CBI is hereby directed to look into the matter and strictly instruct the concerned to conduct the trial in accordance with law and as contemplated under the law. These encomiums. So did I protract the proceedings? Now, my lord, kindly no, it will not stop there.
No worries, he will retract the statement.
Now kindly go to the next paragraph. Without there being any further alternative, the court has reluctantly once again posted the case for fixing the date for trial, since on the last stretch of dates, majority of the witnesses were not examined by the prosecution. What is this allegation against me in paragraph 9? That I am protracting the proceedings? Now kindly go to the 22/11/2024 proceeding sheet. The learned SPP 22/11.
Yes, sir.
The learned SPP has filed a memo along with list of witnesses to be summoned. In the said memo, it is noticed that the prosecution is intending to summon CW 153, Dr. Kumuda Rani, who is an handwriting expert, in order to prove the letter allegedly received by the deceased Yogesh Gowder prior to his murder, which would be deposed by Basuraj Muttalagi. Handwriting expert would come up instead of the rest of the material witnesses. It is relevant to note that the Honorable High Court of Karnataka, by its kind order, has deferred the recording of evidence of approver Basuraj Muttalagi. As such, after recording the evidence of CW 153, the court will have to defer the cross-examination since the evidence of Basuraj Muttalagi is yet to be recorded. That apart, CW 13 and CW 14 are stated to depose about the motive in the above case. It is pertinent to note that some of the witnesses who were examined already by the prosecution speaks about the motive. Eldernu edit sentence so adjourned. Not even their examination chief is complete. For instance, PWT has already deposed about the motive and intention, and even his cross-examination is deferred. On that day, a submission was made that some of the witnesses were to speak about the motive. The court today has posed a question to the learned SPP that how many witnesses cited in the charge sheet would speak about the motive and intention. The learned SPP submits that there are some other witnesses apart from the one who are mentioned above to depose about the motive and intention to commit the murder. Under such circumstances, it is observed that once again the case will be deferred for cross-examination since the corroboration would be required. Unless a particular type of witness is the eyewitness, witnesses who speak about the motive and intention, expert witnesses are flocked together and examined. Effective cross-examination will not be conducted by the defense, wherein the learned counsels for accused have also made a submission that for the purpose of corroboration, they have to be examined together. As such, the list of witnesses proposed to be examined is not conclusive, and in spite of granting a week's time to the prosecution, they have not come up with proper list. It is not the duty of the court to remind the prosecution to file a proper list of witnesses to conduct effective trial. Accordingly, again, my lord, the head of Bureau of ACB CBI, Bengaluru, is hereby requested to provide necessary assistance to the learned SPP in order to prepare the list of witnesses for conducting effective and expeditious trial.
ಇವರೇ ಅಪೇರ್ ಆಗ್ತಾರ ಅಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಪೇರ್
SPP ಬೇರೆ ಇವರೆಲ್ಲ ಇವರು ಇಲ್ಲಿಯವರು ಈ ಅಬ್ಜೆಕ್ಷನ್ presumably he was not kept informed about the encomiums that are given
is not
or the
informed.
compliments that were given by the trial court. But he now, in the statement of objection, he would put the blame on us, saying that we have been protracting the proceedings. That would be the first point. Well, the second submission, well, Your Lordship may kindly see, let me take Your Lordship again to paragraph 19. It is incorrect, wholly incorrect. He should not have made this. That is why, my lord, I want to counter his submissions. It is submitted, my lord, the order itself was not signed. I shall show to Your Lordship on 30th now. Well, it is submitted that the conduct of the petitioners in approaching this honorable court at a belated stage, after a delay of almost 15 days since the passing of the impugned order, is only of the thought the attempt to delay the trial. Well, the order came to be passed on 30th October, no doubt. Well, may I just request Your Lordship,
uploaded on 11th.
well, that signature was put on 11th. I shall take Your Lordship. No, one must be careful and cautious in making certain atrocious allegations. What for it was made? Is it to prejudice the mind of the court? Well, kindly go to internal page 45. The order was passed on 30th of October 2024.
Digitally signed on 8/11/24.
My lord, dictated to the stenographer, grade 1 in open court from 12 noon to 1 p.m. Your Lordship may recall to Your Lordship's memory, last time I made this submission, which has not been seen in any of the orders which came to be passed and pronounced in open court on this 30th day of October 2024. Then, my lord, what the learned judge would say is, digitally signed by so and so, date is 8/11/2024. My lord gets it, my lord? So 8/11/2024 it was signed?
11th, I think it was uploaded. Last time you told me.
My lord, yes. Then, my lord, I would file this on 12/11.
Next day.
Next day, I make a motion before this honorable court on 13/11/2024 to take up the matter in the afternoon session of the day, because on 14th, my lord, the approver was summoned for the purpose of giving evidence in the case. Am I protracting the proceedings? Or I did not tell the trial court to pass wrong orders? I'm sure Your Lordship would certainly agree with me that I have a right. If in my wisdom, my lord, if I were to see that the order that is passed by the trial court is incorrect, inaccurate, illegal, unacceptable, I am not entitled to question it. I am certainly entitled to question it. Ultimately, it is for Your Lordship to decide whether what I have questioned is right or wrong, whether I am justifiable or not. Is it with ulterior motives that I have filed this petition and questioned the order which came to be passed by the trial court? But I am a little bit pained, because this should not have been the statement of objections which came to be filed by the prosecution as stated in paragraph 19 of the statement of objections. Well, now let us go to the merits of the matter now. But this application is under section 306. Well, probably I may have to humbly request Your Lordship to grant me some time, because
ಎಷ್ಟೊತ್ತು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ ಲಿಸ್ಟ್
ಒಂದು-
ಮುಗಿಸ್ಬಿಟ್ಟಿದೀವಿ
ಇಲ್ಲ you ಇದರಲ್ಲಿ probably your lordship have to
ನಾನ್ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ ನೀವು ಎಷ್ಟೊತ್ತು ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
then it is all right.
Yes.
I'm sorry.
I
No,
guess
kindly permit me to take your lordship in detail.
So you
because
can
probably
take any.
probably it may warrant a law being laid down by your lordship in this case under section 306 of the CRPC.
One second.
That's why, my lord, I would like to do it.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ರೆಡಿ ಮಾಡ್ಬಿಡಿ ಅಲ್ಲ.
My lord, he is the first accused in the case. Earlier, the trial was there. Nearly about 66 witnesses came to be examined before the sessions court
By the state.
by the state.
Yes.
He kept quiet for years and years. He kept quiet for years and years. He kept quiet. The matter was even statement of the accused under section 313 came to be recorded.
At that stage it was transferred to the
At
CBI.
that stage, it was transferred and then investigation. Even thereafter, he participated in the proceedings of the case for 3 years, even after the filing of the charge sheet by the CBI. Doesn't matter. Well, I am not concerned with the incident.
ಯಾರು the accused number 1?
Accused number 1 participated in the crime for 3 years.
Because he had himself filed 482 before me.
Yes.
To quash the
Well,
proceedings.
Witnesses were examined. Subsequent thereto, after the trial came to be transferred to the special court, witnesses came to be examined. Well, on 13th of March 2023, on 13th of March 2023, this first accused, now to whom my lord, the pardon has been given, and to treat him as a witness on behalf of the prosecution, would make an application under section 306 of the CRPC.
That is rejected.
13.3. Well, I would like to draw my lord's kind attention
Page.
to the application which he has filed and the order which came to be passed by the trial court on that application.
Page.
The application your lordship would get at page 146. Kindly go to page 146. A one paragraph application, because your lordship the other day posed a question to me. Your lordship may recall to your lordship's memory. Leave alone.
Will SQ 164.
SQ 164.
Pardon
Whether
can be granted.
Can he grant it on the basis of such kind of bald applications? Is the question that warrants consideration at your lordship's hands. Well, kindly permit me to take your lordship to the contents of this application, which is in one paragraph at page 146.
Yes.
That in the top noted case, accused number 1, Basavaraj S. Muttagi, seeking permission for approval to tender evidence as accused number 1 is ready to give tender. Kindly read. As accused number 1 is ready to give tender of pardon. I don't know to whom he wants to give tender of pardon. Doesn't matter, my lord. That is the application which he has filed, probably to the prosecution or somebody. In support of the prosecution. And in this regard, said accused number 1 is also ready to give section 164 of CRPC statement as a confession. Hence, Honorable Court be pleased to kindly accept a tender of pardon. He is giving to the court probably. Accept a tender of pardon of accused number 1, Basavaraj S. Muttagi. And in the support of this application, accused number 1, Basavaraj Muttagi is filing affidavit as the same is made voluntarily without any threat or influence.
Sadly worded. Sadly worded.
Sadly worded. And no basis for the court to have.
So what
given it.
happens to this application?
Well, no. This application came to be opposed by the prosecution.
Oh,
Yes, my lord. Kindly go to,
where is the objection?
yes, my lord, 148. What they say is, no. Issue a direction for recording a statement under 164. But 164 does not come into play no sooner the inquiry or trial commences. It is only during investigation. The court has no jurisdiction at all, either to direct or itself record the statement under section 164. Because till such time, my lord, he is treated as a witness for the prosecution, he is an accused. Kindly go to page 148 now. Kindly permit me, my lord, I shall skip, my lord, paragraph 1 and 2. I shall take your lordship to next paragraph.
He has not quoted how he is going to support the prosecution. So
Yes, my lord, that is the basic essential ingredient to invoke the jurisdiction of the court under section 306. What is his role? What is the role of the other man? What is it that he is going to depose? Well, what the trial judge, I shall take your lordship, did was, no, I am going to give you pardon, but I shall wait whether you are going to support the case of the prosecution or not. Therefore, I will direct the magistrate to record a statement under 164. I will secure it. I will find out. I will read it. Then I will give you pardon. That is, my lord, if I may say so with utmost respect, my lord, that is not the duty of the presiding judge. Kindly go to paragraph 3 now for a second.
Yes.
It is humbly submitted. This is a statement of objection. It is humbly submitted that on perusing the application, CBI could not able to ascertain on disclosure of which facts, fortunately, favorably to me, the petitioner is going to support the prosecution case. Well, it is only for a similar application. It is for this purpose, the learned trial judge, the order impugned, my lord, would direct the magistrate to record.
So what order is passed on this?
No, I shall. My lord, I shall read this. I shall just 4 or 5 sentences,
Yes,
my lord.
yes.
It is further submitted that the affidavit attached with the application also is devoid of merits. It is pertinent to mention that the purpose of section 307 of CRPC is to obtain the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense during investigation or inquiry or trial, and the same could not be proved by the available evidence by the prosecution. Kindly pause for a minute. Well, if the evidence that is which the investigator had collected during the course of the investigation of the crime is certainly insufficient.
According to them, it was sufficient.
My lord,
No, that's what.
8 eyewitnesses in the case. 6, earlier they have been treated hostile. Subsequent to the CBI taking over the investigation, they have examined 2 eyewitnesses. Their statements are there. Their statements under 164 is also there, unless and until they say that from the evidence which we have been able to collect subsequent to the notification issued by the state government is certainly insufficient to make out a case against the accused, then only, my lord, the court can do it. That is what they would say here. And the same could not be proved by the available evidence by the prosecution. Well, kindly read the next paragraph. This would be very, very important. In this regard, it is respectfully submitted that this honorable court may be pleased to direct the petitioner to record his confession statement under 164 subclause 1 CRPC, and after perusing the recorded confession statement of the petitioner, prosecution will be in a position to take the appropriate decision.
Right.
Well, they would make a request to the court to direct the accused to make a statement under section 164, which the court can't do it. Even the magistrate also can't record a statement under 164. I shall take your lordship to the provisions little later after taking your lordship to what is the order which can be passed by the trial court. May I request your lordship to kindly turn to, it commences at page 124. Well, the relevant paragraph, the order commences from paragraph 17 at page 142. But this order came to be passed by the trial court on this application on 29th of April 2023. This order has attained finality. Commences at page 124. Kindly go to page 142, paragraph 17. My lord gets it. I have gone through the sections 306 and 307 and 308 of CRPC. There is no bar either under section 306 or 307 CRPC to tender pardon to an accomplice. And the court can tender pardon any stage of the investigation or inquiry into or the trial of the offense. But there is no quarrel with regard to the jurisdiction of the court during inquiry or during trial. Absolutely no quarrel. The court certainly has a jurisdiction under section 306. Seeking, accused number 1 has filed the application under section 306 of CRPC, seeking tender of pardon from this court. In the application filed by the accused number 1, he stated that he is ready to give tender of pardon in support of the prosecution. And in this regard, he is ready to give statement under section 164 of CRPC, not in support of the prosecution or in support of the defense, my lord. What transpired and what is the role played by him, what is the role played by the other. As a confession and prayed for granting pardon. In the affidavit, he has stated that the contents of the application are voluntarily made and no person has influenced and threatened him to file this application. There are no specific grounds urged under which he seeks pardon. The accused has not stated his role in the case. He has not explained the role of the other accused. He has not stated why he is seeking pardon and how his evidence helps the court to bring home the guilt of the accused. The dominant object is that the offenders of the heinous and grave offenses do not go unpunished.
Para 19, the entire crux.
ಅಲ್ಲ, ಇದೊಂದು ಸ್ವಲ್ಪ
He rejects it for the reason that he has no confidence on the.
ಅಲ್ಲ ಇದೊಂದು ಸ್ವಲ್ಪ ಓದ್ಬಿಡ್ತೀನಿ ನಾನು. ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, kindly pardon me.
Yes.
Kindly pardon. The legislature in its wisdom, no, how beautifully the learned judge has written the order. No, my lord, he does not even refer to this order at all, which is bound to. That is what the Supreme Court has said.
No, seeking pardon will not conclude in one stroke. In the sense today, it is rejected. It is not a bar to seek pardon again. It's a different thing. But this
No.
should have been referred to.
Refer to, that is number one. Number two, when he seeks for the second time the pardon, it must be the change
A
in
change circumstance.
change circumstance. ಇಲ್ಲಿ ಏನ್ ನೋಡೋಣ ಅವನ ಅಪ್ಲಿಕೇಶನ್ ಎಷ್ಟು ತೋರಿಸ್ತೀನಿ ನಿಮಗೆ. Then I will take your lordship with the order. My lord,
On the same circumstance, you can't keep seeking.
can't. My lord, kindly imagine this situation. All the 18 would, there are 17 or 18 accused. One after the other will keep making the applications.
Yes.
No, but kindly go to. The legislature in its wisdom considered it necessary to introduce this section and confine its operation to cases mentioned in section 306 of the court. The object of section 306, therefore, is to allow the pardon in cases where heinous offences are alleged to have been committed by several persons so that with the aid of the evidence of the person granted pardon, the offense may be brought home to the rest. ಇಲ್ಲ ಅದನ್ನ ಹೇಳಬೇಕು ಇವರು. The basis of the tender of pardon is not the extent of the culpability of the person to whom pardon is granted, but the principle is to prevent the escape of the offenders from punishment in heinous offenses for lack of evidence. The prosecution has filed objections and contended that the CBI could not be able to ascertain and disclosure of which facts the petitioner is going to support the case of the prosecution, and the affidavit attached with the application is also devoid of merits. Further, it is contended that this court may be pleased to direct the petitioner to record his confession under section 164(1) of the CRPC, and after perusing the record of confession statement of the petitioner, the prosecution will be in a position to take the appropriate decision. This court cannot direct the accused to give a confession statement under section 164(1) of the CRPC, which is self-incriminating. In this case, the learned judge passes an order directing the accused to go and make a statement and directs the magistrate to record his 164 statement. Kindly read the next sentence, my lord. However, grant of pardon to one prime accused in the case to satisfy that this is the accused who is going to make full and true disclosure of the whole of the circumstances within his knowledge relating to the offense and to every other person concerned, whether as principal or abettor in the commission thereof. Now, my lord, I will take your lordship to paragraph 19, as my lord has pointed out. When the accused is not ready to disclose either his role or the role of the other accused, that is in the application. That is in the application.
Application, correct.
That is in the application. How this court can expect from the present accused that he would make full and true disclosure of the whole of the circumstances within his knowledge relating to the offense? This court is not aware as to how much information is known to the present accused regarding the commission of the alleged offense and whether he had participated in the larger conspiracy to commit murder of Yogesh Gowda, and if so, who is the key conspirator to commit the offense of murder of Yogesh Gowda. I do not think that the tender of pardon will be in the interest of successful prosecution of the other offenders whose conviction is not easy without the approver's testimony. Kindly underline this, Mala. It will be indubitably agree to tendering of pardon. Therefore, I am not satisfied that a tender may be granted to the accused number one, Basavaraj, on the ground that he would make full and true disclosure on the whole of circumstances within his knowledge relating to the offense. He has shirked his responsibility to disclose his role and the role of the other accused in the commission of offenses while filing this application before the court, and therefore this court has no confidence with him that he would make a full and true disclosure of the whole of the circumstances relating to the offense. Therefore, I answer point number 1 is the negative. Application came to be
It has
rejected.
become final.
It became final. It was not questioned. Subsequently, my lord, what would transpire is on 19th of October 2024, a second application came to be filed.
Where do I get that?
Yes, my lord. Probably after the change of guard in the court, a second application came to be filed.
Oh, change of guard in the court.
Change of guard
In the court.
of the presiding officer of the court. my
ಅಲ್ಲಿ
lord.
ಚೇಂಜ್ ಆಗಿದಾರ ಈಗ?
ಚೇಂಜ್ ಆಯ್ತು ಆಮೇಲೆ ಇದಾದ ಮೇಲೆ ಆ ಅಪ್ಲಿಕೇಶನ್ ಬರುತ್ತೆ.
ಯಾಕೆ ಇವರೇ ಅಲ್ವಾ ಇರೋದೀಗ?
ಇಲ್ಲ ಇಲ್ಲ my lord, this is signed by
Special
Mr.
judge is changed, is it?
No, my lord, Special Judge B. Jayant Kumar. Earlier order. Your lordship may kindly go to page 140.
Earlier order is somebody else.
Yes. That is why I submitted, my lord. Your presiding officer. My lord, I have nothing. See, incidentally, I thought of bringing it to your lordship's notice.
No, I thought this present man is. changed.
Illa.
Yes.
My lord, kindly go to page 92 now for a second. On 19th of October 2024, the second application is filed. Kindly go to page 94.
Yes, I am there.
92, I'm sorry, 92.
92, 93.
Very next page, my lord, after the order. Kindly go to 92 now. My lord, para 2. The applicant is facing threat for his life from
Very-
various corners, including the accused number 15 and 16 in this case. The threat faced by this accused is constant. In this case, from the commission of crime till now, the threat perception persists. ಅದಕ್ಕೂ 306 ಸಂಬಂಧ ಇಲ್ಲ. ಥ್ರೆಟ್ ಇದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿ, FIR ಆಗಲಿ, ಅರೆಸ್ಟ್ ಮಾಡಲಿ. And the prosecution on the basis of this statement would even go to the extent of making an application before the court seeking for cancellation of bail. That application came to be rejected. Well, now kindly go to paragraph 3 now. The accused submits that after introspection of the entire event, the accused decided that he should reveal the true facts before this honorable court to save the ends of justice. On the earlier occasion, this accused has filed an application seeking pardon. However, the same was not appreciated by the honorable court as confession statement under section 164(1) CRPC was not available before this honorable court for consideration. ಎಲ್ಲಿದೆ? Where the trial, in the earlier order, your lordship did not find this. In the earlier order, what the court would say is, no, sorry, I can't direct the accused to go and make a statement under section 164. The stage has gone. Inquiry has commenced. Trial has commenced. Witnesses are being examined. Charges are framed. In exercise of the powers clothed upon the court under 164 CRPC, the court cannot direct. And even the magistrate becomes functus officio in recording the statement under 164. Accused submits. Well, kindly go to the next paragraph. Accused submits that he has to disclose the truth before this honorable court for the sake of justice.
No,
And
this accused has been seeking pardon for the third time now.
Second time.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾವ್ದು ಅನೆಕ್ಷರ್ C2 ಅಂತಿದೆಯಲ್ಲ ಅದೇನು? ಅದು ಅಪ್ಲಿಕೇಶನ್
Application.
ಇಲ್ಲ, ಇದು ಡೀಟೇಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಇದೇನು?
ಹೌದು ಇಲ್ಲ ಇದು objection.
ಅಲ್ಲಲ್ಲ.
Your lordship is referring to
Page
90
100 to 103.
100 to 103.
It's a detailed application seeking pardon.
ಅದು IO
IO-ಗೆ.
He writes a letter to the IO.
To the IO, yes.
ಅಷ್ಟೇ. Well, the accused submits that he has to disclose the truth before this honorable court for the sake of justice. And if this honorable court pleased with the disclosure of the fact, it may take appropriate decision to pardon or otherwise. The accused is ready and willing to depose before the magistrate, disclosing his role and the role of the other accused in the commission of the crime. The accused may be provided proper security from the central agency. Well, even in this application also. Well, now kindly go to paragraph 5.
Yes.
The accused, number one, prays the dishonorable court may please to allow the accused to disclose the true facts under section 164 CRPC to attain justice. But this application, which is as barred as it should have been, it doesn't say anything. What is the role? Well, earlier, what the court would pass an order is, "Arey, you should say what is the role you have played? What is the role the other accused have played? To what extent your evidence is going to support either the defense or
So
the
your
accused?"
suggestion is the application should contain everything. There cannot be a recording of 164 statement for the purpose of consideration of pardon.
But here,
No, that's this.
yes,
that's this.
that is the legal. But here, two things are there. 164 can't be recorded at all. I shall show to your lordship presently. 164 can't be recorded. That is number one.
So the first application was barred. The second application is equally barred. The first order rejecting it is there. The second order accepting it is on the ground that 164 statement gives everything. So according to 164 statement is a nullity.
Yes, it is a
If it is
nullity in the eye of
it
law.
should go only on the application.
But the Lorent trial judge will pass the order solely on the basis of statement that recorded under 164.
That's what I see on
I shall take your lordship now.
page 61 of the order on.
Yes, but the accused has said in his 164 statement, the accused has said in his 162. No,
Now you should only tell me the illegality with recording of 164 statement prior to the grant of pardon. That's all. That's all that's necessary.
may I request your lordship to kindly have a cursory look at 164 for a second now?
Yes.
But that,
Oh, if that,
Please,
sorry to interrupt, but
no, my lord,
if that is the
no,
submission,
no, your lordship
then-
is trying to save the
no, if
impressions.
what I have understood is the
Have it recorded.
submission of yours, then it.
No, no, ಇದಕ್ಕೆ ಇನ್ನೊಂದು ನಾನು ತೋರಿಸ್ತೀನಿ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಒಂದ್ಸರಿ
ಹಾ,
ಇದಕ್ಕೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ
ಯಾವುದು CBI.
yes my lord but the second application on the same day ಇವನ್ ಅಪ್ಲಿಕೇಶನ್ 1910
Handwritten objections.
ಹೌದೌದು ಅಲ್ಲೇ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಎಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿದೆ ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 94 ಅಲ್ಟಿಮೇಟ್ಲಿ
99 ಕ್ಕೆ ಬನ್ನಿ. In
94.
view of the discussion, it is
No, no,
humbly
94.
prayed, this honorable court may be pleased to deny the petitioner to record a confessional
ಹೌದು.
statement under 164(1). What deny, sir? Prasanna Kumar. sir.
ನೆಕ್ಸ್ಟ್ ಇನ್ನು ಹೇಳದ
ಅಲ್ಲ,
ಇನ್ನೊಂದು
deny ಅಲ್ಲ, direct ಅದು.
ಅದು ಡೈರೆಕ್ಟ್ ಅಂತ ಇರ್ಬೇಕು
Typography. ಕೈಯಲ್ಲಿ ಡಿನೈ ಅಂತ ಬರೆದು ಡೈರೆಕ್ಟ್ ಅದು.
ಅಲ್ಲದ ಇದರಲ್ಲಿ ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ paragraph 98 now. That is the typed copy, my lord.
Yes, yes,
Handwritten is 94.
yes.
Typed copy is 98.
I have humbly submitted. Of
Yes.
course.
It is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the petitioner is going to support the prosecution version. At least for the
So
first time, they are signing
Now
with
the
me.
entire issue revolves around 164 statement,
ಬರ್ತೀನಿ.
whether that is permissible or not.
ಬರ್ತೀನಿ. ಒಂದ್ ನಿಮಿಷ.
Yes.
Well, then what is the basis for the trial court to have exercised its jurisdiction under section 306? It is for mere asking? Is it for mere asking that the court can exercise its jurisdiction under section 306 is the question, next question. It can't be. That's what the Supreme Court has said. But it is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the ಇನ್ನೂ ಒಂದು ತೋರಿಸ್ತೀನಿ ತಮಾಷೆ 164 ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ it is more a matter of my lord, ರೆಗ್ಯುಲರ್ ಪ್ರಾಕ್ಟೀಸ್ ದಟ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸಿ ಮಾಡಿ ಕೂರಿಸ್ತಾರೆ. ಈ ಲಾಯರ್ನ ಕೂಸ್ಕೊಂಡು 164 ಮಾಡಿದ್ದಾರೆ ಅಂತ ಜಡ್ಜ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಲಾಯರ್ ಕೂತ್ಕೊಂಡು ಅವ್ರ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಿರೋದು. ಐ ಶಲ್ ಶೋ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ನಾವು.
ಅಲ್ಲ, ಎಲ್ಲ ಆಗೋಗಿತ್ತಲ್ಲ, ಇದು 164 at a later stage ಅಲ್ಲಿ ಹೀಗೆ ಆಗದು.
ಅಲ್ಲಲ್ಲ 164 ನೇ ಲಾಯರ್ ಪಕ್ಕದಲ್ಲಿ ಕೂರ್ಸ್ಕೊಂಡು ವಿಟ್ನೆಸ್ ಮಾಡಿರೋದು.
ಮುಂಚೆ ತಗೊಂಡ್ರೆ 164 ಯಾರು ಇರಲ್ಲ. ಇದು ಟ್ರಯಲ್ ನಡಿಬೇಕಾದ್ರೆ 164 ತಗೊಂಡ್ರೆ ಲಾಯರ್ ಇದೆ ಸರ್ ಪಕ್ಕದಲ್ಲಿ.
In fact, ಎಲ್ಲರನ್ನು ಆಚೆ ಕಳಿಸ್ತಾರೆ. Other than the court officers or officials, my lord, whose assistance is needed for the court for the purpose of typing or taking the dictation and all that. ಲಾಯರ್ ಇದ್ದಾರೆ, ತೋರಿಸ್ತೀನಿ. ಅವ್ರ ಲಾಯರು, ಯಾರ ಲಾಯರು? ಅಪ್ಲಿಕೆಂಟ್ ಲಾಯರು, ಅಕ್ಯೂಸ್ ಲಾಯರು. Kindly now go to paragraph 3 at page 98 for a second.
Yes, sir.
It is humbly submitted that on persisting application, CBI could not be able to ascertain of which facts the petitioner is going to support the prosecution version. It is further submitted that the affidavit attached with the application is also devoid of merits. ಅವರೇ ಹೇಳ್ತಾರೆ, fortunately for me, instead of me saying it, they support my cause. It is pertinent to mention that the purpose of section 307 CRPC is to obtain the end of any person supposed to have been directly or indirectly concerned in privy to an offense during the investigation or inquiry or trial, and the same could not be proved by the available evidence by the prosecution. In this regard, in respect, it is respect of submitted.
ಅಲ್ಲ ಅದು ಸಿಂಟ್ಯಾಕ್ಸ್ ಎರರ್ ತುಂಬಾ
ಅಲ್ಲ, typist ಸರಿ ಇಲ್ಲ.
is very bad.
ಅಲ್ಲ ಒಂದೇ. In this regard, it is respectful ಅಂತಿರ್ಬೋದು. We shall read proper. Millard, I am not saying anything.
That's all.
That this honorable court may be pleased to direct. ಇದು ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಪ್ರೀವಿಯಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ, ಅದರ ಕಾರ್ಬನ್ ಕಾಪಿ. It is pleased to direct the petitioner to record his confession statement under 164 on the CRPC, and after perusing the recorded confession statement of petitioner, prosecution will be in the petition action. When the court can't look into it at all, ಇದು ಅವರು ದೇ ಆರ್ ಮೇಕಿಂಗ್ ದಿ ಕೋರ್ಟ್ ಟು ಕಮಿಟ್ ಮಿಸ್ಟೇಕ್ಸ್. ನಾನು ಅದನ್ನು ಕ್ವಶನ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು ಇದರಲ್ಲಿ. ಟೈಮ್ ಅಂಡ್ ಅಗೇನ್ ಯು ಆರ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಅರೆ, ಯು ಆರ್ ಮೇಕಿಂಗ್ ದಿ ಕೋರ್ಟ್ ಟು ಕಮಿಟ್ ಬ್ಲಂಡರ್ಸ್. ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿಸ್ಬಿಡಿ, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ ಅವ್ರ ಪ್ರೇಯರ್, ದಟ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್. ನೋ ಮೈ ಲಾರ್ಡ್, ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್. Kindly go to C2, Milan. C2.
Yes,
Date illa, month illa, time illa, on application.
C2, sir.
No, C2.
Page
100. Your lordship has referred to it little earlier.
tender.
Not before, made by the,
Yes,
before the
yes.
investigation. Same thing. It is of no consequence.
Yes, sir.
May I now request your lordship to kindly go to the order which came to be passed by the Law and Trial Judge at page 47
Yes.
on 13th of October 2024. Commences at page 47.
Yes.
But I shall skip facts of the case. The Law and Judge would write. Kindly go to page 57 now. At the bottom, last two sentences at the bottom of page 57.
And very extractions, sir. Reasons commence at 63. Shorn of unnecessary.
ಅಲ್ಲ, ರೀಸನ್ಸ್ ಮುಂಚೆ ಇಲ್ಲಿ ಬರೀತಾರೆ, ಏನ್ ಬರೀತಾರೆ, ಇದೊಂದೇ ಸೆಂಟೆನ್ಸ್ ಬರೆಯೋದು. Earlier order ವಿಚಾರ, ಅದಕ್ಕೋಸ್ಕರ ಐ ಆಮ್ ಜಸ್ಟ್, ಐ ಥಾಟ್ ಆಫ್ ಇನ್ವೈಟಿಂಗ್
Page 57, sir.
Yes, well, page 57, last two sentences. It is also been submitted that on an earlier occasion, because your lordship posed a question, has he referred to it or not, filed an application seeking pardon. However, the same was not considered by this court, as his confession statement under section 164 CRPC was not available before this court. No?
No, one moment, sir. His 164 statement was recorded by the state and by the CBI earlier.
No?
No, no, not for the purpose of 306.
No?
For,
Accused, Miller, how could they record his?
accused.
He is the accused.
Yes.
They could not have. He would not have obliged. For more than one reason, he is now obliging.
Now, the question is, 164 statement, as I have known, is recorded prior to the commencement of the trial.
Right.
Once the trial commences, recording of 164 is not available.
Not
That is
available.
what, subject to correction.
No, I shall take your lordship to the provisions of law.
So if 164 cannot be recorded after the commencement of the trial or at this stage of trial, whether it can be done for the purpose of 306 is what is.
Adu, the statute should clothe powers upon him.
Yes, 306.
No, no, whether it is 306 or 161 or whatever it may be, my lord, the magistrate has no jurisdiction to record. The learned sessions judge
Could not
is
have
asking him to
directed
commit a mistake. He's asking him to commit a blunder by issuing a direction to the magistrate, which he could not have done under the statute. Well, I shall take your lordship to the provisions of law.
Now, for illustration, if this is permitted, now every court, court of session during the trial May direct magistrate, you record 164 statement and get it before. me.
ಕ್ವಶನ್ ಮಾಡಿದಾಗ ಈ ತಾಪತ್ರೆ ಆಗುತ್ತೆ, ಕ್ವಶನ್ ಮಾಡದೇ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರುತ್ತೆ. If it is questioned before your
Yes.
lordship,
Yes, sir.
then the problem arises. Otherwise, no. But what the law says is, first tender pardon and then record statement. Ili putting the cart before the horse.
No, after tendering pardon, definitely it is cross
ಅಷ್ಟೇ,
examination.
ಅದೇ ಅಷ್ಟೇ ಇರೋದು, ಇನ್ನೇನು ಇಲ್ವೇ ಇಲ್ಲ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ನಲ್ಲಿ.
After tendering pardon, he will give examination.
ಅಷ್ಟೇ.
Recording of
ಅದು
statement.
ಬಿಟ್ಟು ಬೇರೆ ಏನು ಮಾಡಕ್ಕಾಗೋದೇ ಇಲ್ಲ. But for the purpose of finding out whether he is going to support the case of the prosecution, he can't be directed to go and.
One clarification. Once he's tendered pardon,
Yes.
after tendering pardon, the court-
164 ಇಲ್ಲ.
what is that statement?
That is regular evidence.
It is not 164.
Oh.
So I just.
Well,
want to
what
know,
happens is this-
164 is not available after the trial commences in terms of this
He
statute.
becomes a witness for the prosecution.
Yes.
He becomes a witness for the prosecution. And after the trial commences, no one can record his 164. Well, kindly go to, well, where does he find this, the Laran judge? However, the same was not considered by this court as his confession statement under section 161 CR was not available before this court. No, what the Laran judge, I invited my lord's attention, he says is that I can't direct the accused to make a statement under section 164 because that becomes inculpatory. I can't ask him to make evidence against himself.
No, that is true.
That is
Unless-
how the Laran judge does not dispose of the application or reject the application on the ground that your 164 statement is not there. No, he dismisses the application on the ground that your application is bald. It does not contain the details that are needed. I can't direct the recording of the statement of the accused under 164. You have not shown or said anything about the role which you have played and the role which the other accused have played so that I could come to a conclusion. That is number one. Number two, my lord, he would also dismiss the application on this score that unless and until the prosecution contends, but for his evidence, as an approver, it is difficult for us to make out a case against the accused. That is the law. That is the correct legal position.
So after granting pardon, he is subjected to examination and cross-examination. In a normal way, evidence takes place.
He becomes
during-
a witness for
during
the
the trial.
PW1, he becomes
He's a
PW1,
witness.
PW2, PW3.
The accused is transposed as a witness,
it.
he is examined and
My-
cross-examined.
My
by
lord,
the-
instead of a larger box, he comes into a smaller box.
Yes.
That's all. Larger box is more than one accused. Smaller box is a witness box. He steps in there. He stands alone, not with his other companions. He stands all alone.
So that's the difference, that's all.
That is it. No, but kindly see, this is incorrect. Accepting this, it is also submitted that he was ready to disclose the truth for the sake of justice. And if this court permits him to disclose the fact, he was ready and willing to divulge. On the filing of the impugned application, this court had requested the Larat 17th additional CMM Bangalore to get his statement recorded. Larat 17th additional CMM Bangalore, after following the statutory bound and after providing, ಎಲ್ಲಿದೆ ತೋರಿಸ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಅವ್ರನ್ನ ಲಾಯರ್ ಪಕ್ಕದಲ್ಲಿ ಕುರ್ಚಿ ಹಾಕೊಂಡು ಕೂತಿರೋದನ್ನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ. But I am not building castles in here. I stand by that.
No, no, it's obvious, you need not even say, you will obviously be there because it is recorded at the stage of trial.
ಅಲ್ಲ ಇದಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್.
If direction ಕೊಟ್ಟಾಗ್ಲೂ ಅಲ್ಲಿ ಲಾಯರ್ ಇದ್ರೋದು.
ಇದೇ ಲಾಯರೇ. The lawyer who was representing this first accused during the trial of this case till the date of his application becomes the lawyer for him to make the application under section 306. And it is the very same lawyer who files the wakalatnama at a point of time when his statement under 164 came to be recorded by the magistrate. Signature ಹಾಕ್ಬಿಡ್ತಾರೆ ಅವರು. ಎನ್ರೋಲ್ಮೆಂಟ್ ನಂಬರು, ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಅವರು ಇರ್ತಾರೆ, ಕೂತ್ಕೊಂಡಿರ್ತಾರೆ. ತೋರಿಸ್ತೀನಿ ಒಂದು 2 ನಿಮಿಷದಲ್ಲಿ ತೋರಿಸ್ಬಿಟ್ಟು.
All right.
ಇದರಲ್ಲಿ
He could not have direct.
Malad, yet on the filing of the impugned application, the court had requested the Larat 17th additional CMM Bangalore to get his statement recorded. Larat 17th additional, after following the statutory, etc., he recorded it. Number one, he could not have recorded it at all. I mean, directed it at all. Number two, he has also not recorded as mandated under law his statement under 164. Number three, if everything is in order, he could not have placed reliance on the statement said to have been recorded under 164 for the purpose of granting pardon to the accused.
Now, whatever he has deposed under 164, if that was the part of the application under 306, there should not have been any problem.
No, even then 164 can't be
No,
done.
that's all right. ನಾನು ಕೇಳ್ತಿರೋದು.
Yes.
ಈಗ 164 ಅಲ್ಲಿ ಏನೇನು ಹೇಳಿದ್ದಾರೆ ಅದು 306 application ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ
ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ
there is no
probably that would have been the ground. That would have been the ground.
problem.
But now kindly go to what he says is at page 60 at the top. In response being filed, it has been specifically narrated in length by the learned SPP with respect to the fact that how the statement of accused number one, Basaraj, so and so was recorded under section 164, 1 CRPC is relevant to be considered his application. In the said application, he has specifically submitted that the letter addressed by the et cetera, et cetera. My lord, now let us go to the reasons, as my lord has said. Kindly go to my lord, I shall skip the first two pages, 64 and 65. Kindly go to 66, 66, para 12. Even a copy of the said statement was supplied to the IO, who had filed his additional response to this court, stating that the accused number one has disclosed true and real facts of the above case. Well, when the trial is in progress, the issue can't be only between the prosecution and the court. I am a party. Ultimately, I am the man who gets aggrieved. I am as much a party to the case during trial as the prosecution is. The trial court ought to have given me notice. Look here, so and so is before the court. What have you got to say? As could be deciphered from the statement and also from the response which was filed by the CBI, it could be noticed that the case of the prosecution is entirely based on circumstantial evidence. That is wholly incorrect. That is wholly incorrect. It rests on the statements of 8 eyewitnesses. It is also not in dispute that the case of the prosecution rests upon the statement of various witnesses, where it is alleged that the accused persons have joined together to hatch a Who has not disputed, Miller? It is also not in dispute means, did I agree at any point of time before the court that I had hatched a conspiracy? That is put for trial. I am charged of an offense under section 120B. It is also not in dispute means who? I am not a party to this order. I am not a party to the application. I am not a party to the statement of objections. Everything is done behind my back. And the learned judge would say, it is not in dispute to hatch a conspiracy for committing a murder of so-and-so on the fateful day. It is relevant to note at this juncture that the response which is filed by the CBI would indicate of various facets which are coming to picture during the course of investigation. For instance, I have called out the necessary materials which are forthcoming in the additional response, etc. Madam, I shall just invite my lord's attention to one word and then keep proceeding. The statement of accused number one discloses. Number two,
ಅದೆಲ್ಲ ಕಲ್ಲಿಂಗ್ ಔಟ್ ಅಷ್ಟೇ
ಎಲ್ಲ 164 ಸ್ಟೇಟ್ಮೆಂಟ್
ಅಲ್ಲ. ಅಡಿಷನಲ್ ರೆಸ್ಪಾನ್ಸ್ ಆಫ್ ದ ಸಿಬಿಐ ಕಲ್ಔಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದರ ಅದೇ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಸಿಬಿಐ ಇನ್ನೇನು ಬರುತ್ತೆ
ಅಲ್ಲ
ಹೇಳೋದನ್ನ.
ಅಡಿಷನಲ್ ಈ ಕಲ್ಔಟ್ ಮಾಡಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಆರ್ ಆಲ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್.
164 statements which are reproduced by the CBI in its additional statement of objections.
Because the court at page 72 goes to say that when the entire facts are once again carefully appreciated with the statement of accused number 1 recorded under 164 does indicate so and so.
My lord, ಇದರಲ್ಲಿ he was an accused, arrested, the notice of the crime came to be registered. ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದಿಲ್ಲ 164 ಇಲ್ಲ ಅವಾಗ. If at all there is any statement, the statement would be under section 27.
Correct.
That statement may not can't be adverted to or looked into for any other purpose other than for the purpose that is enumerated in section 27. ಅದರಲ್ಲಿ ಇದು ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಇವ್ರಿಗೆ?
No,
ಇವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದಾರಲ್ಲ
entire order is based upon 164.
164 entire order.
Yes. ಅಲ್ಲ, because paragraph 14
Yes, madam. Yes, ma'am.
para 14 ಅಲ್ಲಿ one paragraph,
ಹೌದು
ಮಿಕ್ಕಿದೆಲ್ಲ that is extraction.
ಅಷ್ಟೇ.
Para 15 one paragraph, others is extraction. Para 16 again 16 and 17 all 164 statements.
164 state. But now it would be useful for me to invite my lord's kind attention. First, he directs the recording of statement. Thereafter, he gives pardon. That is impermissible.
The procedure is grant pardon and record statement, but not under 164.
No, he has to record.
That is
In the form of
during the
evidence,
course
in
of the
form
trial.
of evidence. No, no, may I just now, for 164, may I just invite my lord's kind attention to the proceeding sheet. Go. I have the certified copy. ಏನಿದೆಲ್ಲನೂ CBI ಅಂದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು ಅಂತ. That is the notion. Anything and everything they can do and undo things. No. Most of the time, my lord, the lawyers who are practicing in the trial court have come across the IVO going and sitting in the chambers of the judge, the prosecutor going and sitting in the chambers of the judge, or the judge, the trial court judge, just sending a message to the prosecutor or to the IVO to come. Case called out 21/10/2024. Case called out before the open court on 21/10/2024 at 1 p.m.
And his counsel are present before the open court.
ಅದಲ್ಲ ನೆಕ್ಸ್ಟ್ ಇನ್ನೂ ಸರಿ ತೋರಿಸ್ತೀನಿ. ಫಸ್ಟ್ ಇದನ್ನ ಓದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದನ್ನ ತೋರಿಸ್ತೀನಿ ಅದನ್ನ.
Nagendra Naik.
ಹೌದು.
Yes.
Accused number 1 by name Basavaraja Shivapambuthige and his counsel are Nagendra Naik, so on. I'm sorry, I read it. Counsel are present before the open court. The procedure before the recording of statement of the accused under section 164 CRPC is conducted since 1 p.m. and the procedure is separately recorded. Further, the statement of the accused number 1 under section 164(1) of the CRP is recorded since 1:07 p.m. to 3:25 p.m. in the presence of the counsel for the accused
Correct.
number 1.
There.
Is that the procedure which is required to follow? My lord? But now, my lord, may I request your lordship to kindly, your lordship has been repeatedly posing that question to me. What is the scope of section 164? Whether after the commencement of the inquiry or trial,
We'll see that.
whether either the trial court, which is the court of original jurisdiction, in this case a sessions court, or a magistrate, my lord, could direct or record the statement under section 164. Would you lordship? My lord gets it?
Yes.
Any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case, but in this case he has no jurisdiction, but whether or not he has jurisdiction or not, record any confession or statement made to him in the course of an investigation under this chapter. My lord, this is under chapter 12, if I am right, my lord.
Yes, investigation.
Under chapter 12. Chapter 12, my lord, commences from section 154.
Yes.
That is registration of the crime.
Crime. Yes.
Then 155 non-causable offense, 156 is the powers of investigation. Then my lord 169 and then 173, 172 and all that.
Yes.
During
Okay.
the course of investigation. or
Before
statement
the
made
commencement of.
under this
inquiry or
chapter,
trial.
under this chapter, or under any other law, or under any other law, for the time being in force, or at any time afterwards, before the commencement of the inquiry or trial, he lacks in jurisdiction. Law does not. When law could not and did not, the court could not have closed the jurisdiction upon the magistrate to record his statement. That is illegal. It is an illegal law. He could not have. If my lord were to eschew, while accepting my submissions, that the magistrate had no jurisdiction to have recorded the statement under 164, but when the learned trial judge has placed reliance only on the 164 statement, this order has got to go. This order will have no legs to stand at all.
Anybody?
But now kindly go to section 306 for a second.
ಅಲ್ಲೇನಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಅಲ್ಲಿದೆ.
164 permission.
ಅಲ್ಲ ಫಸ್ಟ್ ಪಾರ್ಡನ್ನು ಆಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅದು ಗೊತ್ತು.
ಇದರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ
ಇದೆ, ಅದು ಗೊತ್ತು.
ಆರ್ಡರ್ ಬೇಕಾದ್ರೆ ಓದ್ತೀನಿ ಅದನ್ನ. He says, go there, give your statement, I will verify whether what you have said or not.
That is why, see, the court has cautiously done it. It does not record the statement itself. Otherwise, it would have become trial during the course of trial. Before granting of pardon, that cannot be done. So record the statement, take that statement and continue the trial.
ಅದೇ ಆಯ್ತು, ಇವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಬ ಹೋಗುತ್ತಂದ್ರಲ್ಲ, ಅವ್ರಿಗೇನು ಅಧಿಕಾರ ಇದೆ ಮಾಡೋದಕ್ಕೆ ಅನ್ನೋ ಪ್ರಶ್ನೆ ನೆಕ್ಸ್ಟ್. ಇಲ್ಲ, ಎ ಪ್ಲೈನ್ ರೀಡಿಂಗ್ ಆಫ್
Unless he
unless my lord were to interpret,
demolishes.
my lord were to interpret, my lord, section 164, ultimately we have got to carry what my lord is going to pronounce in this case on our shoulders. Unless and until my lord interprets, no, despite the fact that the famous of law in their wisdom have said that it is only during investigation, at any rate, not subsequent to the commencement of inquiry trial, my lord, that becomes the law of the.
Now grant with a view of obtaining evidence of any person supposed to have been
My lord,
directly.
Karnataka criminal rules of practice, have a look at this, my lord, for a
Karnataka
second.
criminal rules of practice.
Yes, my lord,
Yes.
Karnataka criminal rules of practice. Chapter 5.
Hmm.
Chapter 5, Rule 5. ಏನಿದೆ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಇಲ್ಲಿ ಸಿಗಲ್ಲ, ಕೊಡಿ ಅಲ್ಲಿ ಇಸ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ಬುಕ್ ಇಲ್ಲ ಇಲ್ಲಿ
ಇಲ್ವಾ?
ನಿಮ್ಮ ಹತ್ರ ಸಂದೇಶ್ ಗೌಡ ಸರ್ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಏನಿದೆ?
ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್. ಚಾಪ್ಟರ್ ಎಸ್ ಸರ್.
Rule 5, my lord, chapter 5. When an accused person is produced before a magistrate.
Recording confession statement.
Statement, the magistrate should explain to him that he is before the magistrate.
ರೆಕಾರ್ಡಿಂಗ್ ಕನ್ಫೆಷನ್
ಹೌದು,
ಸ್ಟೇಟ್ಮೆಂಟ್.
ಹೌದು. ಅವನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಇವ್ರು. is produced before a magistrate for recording a confession statement. He can't be directed, you go and do it ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಅಲ್ಲ,
Procedure.
even otherwise, my lord, this is of no consequence.
ಎಸ್.
But now 306, have a look at section 306 for a second. With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence to which this section applies, the chief judicial magistrate or metropolitan magistrate at any stage of the investigation or inquiry into or the trial of the offence, and the magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or trial may tender pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the.
But the only worry is subsection 4 of section 306.
Yes. Every person accepting, every person accepting a tender of pardon made under subsection 1 shall be examined as a witness in the court.
Court of magistrate and then
Taking cognizance of the offence.
and then in the trial.
Then, ಅಲ್ಲಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ, he is the magistrate because it is a court of original jurisdiction.
Yes, that for original
Therefore, my lord,
jurisdiction.
that means he can do it. You shall be examined as a witness in the court of the magistrate taking
And
cognizance of the offence
Every
and
person,
the subsequent trial.
every person accepting a tender of pardon in the
ಹೌದು.
sense the order of pardon ಆದ್ಮೇಲೆ.
ಫಸ್ಟ್ ಪಾರ್ಡನ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅದನ್ನ ಬೇಕಾದ್ರೆ ಒಂದ್ಸರಿ ಒಂದು
ಇದೆ, ತೊಂದ್ರೆ
ಇಟ್ ಇಸ್ ದೇರ್.
ಇಲ್ಲ, ಅದು ಗೊತ್ತಾಗಿದೆ.
Yes. ಅಲ್ಲ,
164 ಆದ್ಮೇಲೆ pardon.
ಏನ್
Pardon.
ಮಾಡಿದಾರೆ ಅಂದ್ರೆ,
No, ಇಲ್ಲಿ the drill went like this. Application is filed. On that application, he is referred to the magistrate for recording of 164 statement. 164 statement is recorded and the same is placed before the court of session as a special court here. Special court records all that is there in the additional objections or the 164 statement, and based on that, the court finds that there is ample material to demonstrate that he is going to depose in favor of the prosecution, so I grant pardon. That's the drill that is followed.
Lord, I have any number of judgments on this point. If my lord is persuaded to accept my submission,
One-
the facts of the case.
One the other judgment.
Yes, ma'am. My lord's judgment itself is there. First pardon ಆಗ್ಬೇಕು.
Mine.
That ಮಲ್ಲಿಕಾರ್ಜುನ ಶಿಪ್ಪಿಂಗ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕೇಸ್ ನಲ್ಲಿ ಏನಿದೆ, ಹೌದು, ಇದು ಈ ಜಡ್ಮೆಂಟ್ ಮೇಲೆ ಅವರು ದೇ ಆರ್ ಪ್ಲೇಸಿಂಗ್ ರಿಲಯನ್ಸ್, ನಾನು ಇದ್ರ ಮೇಲೆ ಐ ಆಮ್ ಆಲ್ಸೋ ಪ್ಲೇಸಿಂಗ್ ರಿಲಯನ್ಸ್. Can you go to page 8 of the judgment? First pardon ಆಗ್ಬೇಕು ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. Only for that limited purpose I am drawing my lord's attention. Internal page 9, my lord. Kindly go to page 8, internal page 8 of the order. First paragraph, last two sentences. I deem it appropriate to notice the said provision, section
Yes.
306 of the CRPC reads as under. My lord would
Repeat.
quote section 306 and thereafter
Yes.
page 9, last two sentences. Section 306 mandates consent court to accept an application filed seeking tender of pardon to any accomplice in the crime, subject to the condition that once pardoned, he should make a full and true disclosure of the whole of the circumstances within his knowledge to the court concerning the issue.
ಇಲ್ಲಿ CBI had no objection. The co-accused had challenged it.
First pardon ಆಗ್ಬೇಕು. Well, that is what the statute would say. Then he becomes a witness. But till such time he is
But
given
anyway, 164 is impermissible.
impermission.
That's all. That led in your other, you want to say something?
ಆಮೇಲೆ ಇನ್ನೂ ಒಂದೇನು ಅಂತಂದ್ರೆ ಸೆಕೆಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಮೆಲಾಡ್ ವಾಟ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
Change circumstance.
ಚೇಂಜ್ ಬೇಕು.
That-
ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಐ ಶುಡ್
ಅದು ಕೊಟ್ಬಿಡಿ. As far as I heard, that is the circumstance. It's like bail.
just like bail. Just otherwise, Malad, what happens is he keeps making application after application till the trial is concluded.
It
Trial gets concluded, no sooner the judgment is
it is
pronounced.
akin to making an application bail and change.
This is in
circumstance.
1973. A learned three judges bench, a larger bench judgment, Malad, a full bench
Mhm.
judgment. Kindly go to paragraph 15. This is what the Supreme Court would say. Well, at the middle of this paragraph, the mere fact that a magistrate of the first class inquiring into the offence has declined to grant pardon, as in the case before us, does not take away the power of or jurisdiction of the district magistrate. Well, he becomes the appellate authority in this case. During those days, my lord, under the old code, district magistrate was the appellate authority. District magistrate to entertain a further application for grant of pardon. Though the district magistrate has got power to consider a further application, nevertheless, it is needless to state that he will have due regard to the views expressed by the magistrate for refusing to grant
No,
the
there
pardon.
district court had refused pardon.
Yes.
The subordinate court accepts pardon without any change circumstance.
We
So
must,
the-
however, state that judicial propriety requires that if a higher authority had declined to tender pardon, a lower authority should not grant pardon except on fresh facts which were not and could not have before the higher authority when he declined to grant the pardon. Even if the pardon has been refused on one occasion, a further request may be made. This is what my lord wanted to know from me. A
Yes.
further request may be made before the magistrate or the district magistrate, but such further request can be entertained and considered only if fresh or additional facts are placed by the party
No,
concerned. ಆಮೇಲೆ ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪ್ಲಿಕೇಶನ್ their lordships to the Supreme Court while dealing with petitions which came to be entertained by the High Courts under section 482. But on the day when I made the first application invoking the jurisdiction of the High Court under section 482, I had more than one ground that was available to me on the very day itself. But I am before the High Court under section 482, only urging one ground. Rest of the grounds, my lord, I don't urge. My petition got dismissed. But again, I would make an application invoking the second ground that was available. If that ground was also available on the first day when I made the first petition, second petition is not maintainable. But they would dismiss
Second
it.
petition is maintainable only on change circumstance.
In this case,
You cannot, you see, what the Supreme Court says in that is, you cannot urge grounds in piecemeal. You should come out whole hog. Yes.
my lord, in identical
I-
this court,
I guess that is the word that is used.
my lord, this court, my lord, this one, my lord, is in 2023.
Yes, sir. This is a piecemeal judgment. is
Yes,
it?
ma'am. Well, this court while dealing with an application filed under section 311.
Para 11, same. Yes.
Well, this court in another petition, while dealing with an application filed under section 311 seeking recall of the witnesses who were examined and discharged. Well, a second application came to be filed on the same ground. Well, in paragraph 4, the learned judge of this honorable court would say, learned trial judge on consideration of the material on record has recorded a finding that the petitioner had filed an identical application on an earlier occasion and the same was rejected and so on and so. Without challenging the said order, the petitioner has filed this same application again. Learned trial judge has also recorded that one of the grounds urged in the application is that the previous advocate was not aware of the documents which were in possession of the petitioner. He has recorded that the petitioner had filed an identical application on an earlier point of time and the same was rejected and that the said order has attained finality. It is not in dispute that a similar application was filed earlier and the same stood rejected. The said order, which attained finality, was not challenged. Therefore, it came to be dismissed.
Yes, Sandesh sir. Yeah,
But
ನೀವು
The
ಯಾರಿಗೆ?
other day,
Sir.
the learned special public prosecutor raised an objection with regard to the maintainability of our petition.
Why?
Lucas,
Locus,
they were on.
he has raised the objection.
Co-accused cannot challenge it, is what they were trying to counter.
Have I said so in the other petition?
No, no, my lords. They are relying on one of the Supreme Court rulings where, my lords, they pointed out locus so far as co-accused, but immediately the next line says court has suo motu powers.
Your lordship noted that
So
also.
revisional powers and inherent
motu.
powers court has. We are the ones who are bringing it to the notice of the court. My lords.
But no one has a right of revision under section 397. The court may, did not shall.
My lords, I'll keep it very brief.
And
Extensive,
inherent
it's been
powers.
argued. My lords, first of all.
I only want that point.
First of all, my lords, this entire application which is filed under a wrong provision. In a committal, my lords, an application doesn't lie under 306, but under 307. My lords would notice 307. Once there's a committal done, 306.
It is only under 307.
Only under 307. For 307, my lords, only clause of 306 which applies is clause 1. That's all is the equivalence to it. So, my lords, the very first aspect is, my lords, the 306 application on its own could not have been maintainable unless read with 307. That should have been the first. In my respectful submission, my lords, there are 4 points for consideration, my lords. One is, can a successive application under 306 or 307 be filed without showing any change in circumstance? Very, my lords, like how bails are. Second, my lords, whether a co-accused has locus to challenge an order passed under 306. Second aspect, my lords. Third is, at the time of considering this application, can the court direct a 164 statement to be recorded? Very extensively, it's been pointed out, my lords. It comes under a different chapter altogether and at the stage of investigation. And last is, my lords, will there be a doctrine of res judicata, constructive res judicata, then, my lords, issue-based estoppel? Because once a finding has been given on an issue, my lords, can it be re-agitated through another application? These are the 4 aspects. Now, while considering these 4 aspects, the present interim order, my lords, lack of application of mind,
Interim
this
order.
order, 306 order,
306.
306 order, my lords. 4 aspects are very glaring, my lords. Lack of application of mind when we say, my lords. Wrong provision mentioned, not considered. It's all right, my lords. That's one aspect of it. Second, referring the accused under 164.
1 second.
Second is, my lords, referring under 164. Absolutely could not have been done. Third, my lords, no reasoning as to why the previous order required a revisit. An order which had attained finality, why did it require a revisit? Merely because there's a change in a presiding officer cannot be a reason, my lords. Fourth
No,
aspect
there-
of it. No condition.
There is no revisitation. It's a fresh application.
No change in
Whether
circumstance.
that will consider.
Because unless, my lords, the court felt at that point of time, probably the court was right in not having accepted that application. But now, for these change reasons, I'm accepting it something else, my lords. And fourth, my lords, no condition that has been imposed after you grant pardon. Most important is that, my lords, under 306, first you grant a pardon, then you have to impose a condition. The condition we find under 306(1) itself. You have to depose.
Yes.
That condition has to be there. Now, from the impugned order, my lord,
No, it's only allowed.
allowed, no condition imposed. These are the 4 aspects on lack of application of mind. The judgments, my lords, today I've culled out, my lords, so it becomes easy.
Paragraph number ಬರ್ದಿದ್ದೀರಾ?
Paragraphs I've culled out, right? So kindly notice,
Makes
my
our
lords.
job easy ಅಂತ ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ.
My lords, the first aspect there in the first page regarding a second 306 application not being entertainable without there being change in
Senior referred to
circumstance.
Kailashnath Agarwal.
Yes, my lords. And next, on the next page, regarding the locus of co-accused challenging an order, the very same judgment. 1973, paragraph 8 and 23.
Yes.
Then,
No,
my lords,
I have no doubt over it. So don't
and
worry.
there again, the CPI versus Ashok Kumar Agarwal, which they were relying on,
Hmm.
that speaks about, my lords, suo motu powers that the court has.
Yes.
Then, my lords, the third aspect in page 3, concept of res judicata, its applicability to criminal cases. These are the judgments that deal with it, my lords. It is applicable even in criminal cases, though it's a concept in civil law, my lords. It is applicable here. I've put in 2 judgments there, my lords. And at page 4, regarding the need to have a material change in facts or law prior to maintaining a second application, 2005 2 SCC, page 42. Though in the context of bail, my lords, at paragraph 19, this is what they say, my lords. Paragraph 19.
Yes.
Then, my lords, on page 5, doctrine of issue estoppel. If an issue has been decided, then, my lords, that's the one. And 6, doctrine of constructive res judicata. I have culled out 1 judgment, my lords. At page 5.
Yes.
Then page 6, my lords, the procedure contemplated for grant of pardon is to treat the accused as an approver and then record his evidence. My lords, you get that at page, and I've relied on 1994 supplementary to SCC 73. They very clearly say, my lords, it's only after grant of pardon that
No,
the
the
status of
Provision
an
itself,
accused-
provision itself speaks.
and that's how they have culled that out, my lords. Status of an accused is changed into that of a witness, and the law enjoins upon the court to record the statement of the approval. Then, my lords, page 7, there is no procedure permitting of a statement under 164 of CRPC to be recorded prior to grant of pardon, either under section 306 or 307. My lords, one decision which we have put there, my lords. Then 9, my lords, the title of the petition is irrelevant. My lords, Asian resurfacing, when they say. So, my lords, these are the judgments that have culled out the relevant portions of it, my lords. However we look at it, this entire order will have to go.
Ready, sir? Anything?
The first application, not your lordship will find. The reason, my lord, for rejection of the first application. Not sir, page 144, para 19.
Yes. Para 19.
Para 19, my lord, after about 4 lines from the top. This court is not aware as to how much information is known to the present accused regarding the commission of the alleged offense and whether he participated in the larger conspiracy to commit the murder of so and so. But it was not made known, not to the learned special judge, as to
Right.
under what circumstances how
Correct.
it was done. Now, my lord, kindly have a look at
Not made known where? In the application.
in the application, or not otherwise also.
All right.
Or otherwise.
Otherwise,
Now,
ಹೆಂಗೆ made known?
now, my lord, kindly have a look at the,
Phone ಮಾಡಿ ಹೇಳ್ಬೇಕಷ್ಟೆ.
kindly have a look at, not the page 98.
Hmm.
The report, my lord, filed by the investigating officer
Hmm.
to the second application,
90?
98, my lord, the typed copy which your lordship not was pleased to.
Ah, yes, that's
see.
it. No,
Now,
this is the second
application-
application for pardon.
Second application for pardon.
98 is your objection.
Not this is, not, we have stated as IO report by objection.
Ah, that's what.
But this IO report, kindly have a look at not page 99,
Yes.
not the 4th line from the top. I am also enclosing a letter of the petitioner addressed in the instant case.
Oh, that is page 100.
This is not page 100.
This was available then also.
No, this was not available then. This was
What
not
is the
available then.
date of this letter?
But this was, may not hand over, may not to the IO.
No, no, what is the date of this letter? It is undated. It is undated.
Oh, this, no, this was not available earlier. No, this was
What is the date, sir?
date either illa, not I can
Arre, it is
find out on
undated.
what date, not it was, this was hand over, not to the IO.
True, sir, but what is the date of this?
Not
Only
date.
to say that this was available to the previous application also. Now, if
was
it is
not.
not, if it is not, then what is the date of this?
No, that I can not find out the date, not and this was not available. This letter was not available because there's absolutely no reference, not to this letter, not even in my earlier report of the IO or not the objections not by the prosecution or in the order. There's absolutely no reference not to this
All right.
letter. But
Fine.
this letter, the accused number one may not to disclose, not completely, not what the facts were not within his knowledge. Or if for any reason, but this honorable court were to come to conclusion.
One simple question. If the accused had already penned this down and submitted to the investigating officer,
Please.
what was the impediment to pen everything in the application by the same person?
Not 306 may not doesn't say that everything
No,
must be stated. in
Not
the
everything,
application.
Allah. What are the he has to say, these are the things
Not-
that I
kindly
have
a look
to,
at- no,
I
kindly have a
am
look at-
wanting to depose in favor of the
Kindly
prosecution.
have a look at not page 92 is application.
ಅಲ್ಲ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಬಿಡಿ.
ಅದರಲ್ಲಿ
ಹಾ.
not para 2. The applicant is facing threat for his life from nearest corner, including
ಆಯ್ತು.
accused number 15 and 16. In this
ಅಲ್ಲ.
case, then may not-
ಇದ್ರ
kindly
ಮೇಲೆ
have a look at
ಮಾಡ್ಬೇಕಾಗಿತ್ತು
next page,
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್,
please. Madam.
ಇದ್ರ ಮೇಲೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತು 164 ಯಾಕೆ?
Not,
ಇದ್ರ ಮೇಲೆ ಮಾಡ್ಬೋದಿತ್ತು ಬೇಕು ಅಂದಿತ್ತು.
I mean, that's what not my submission to my lord is. Not the statement may not made it paragraph number 3 and 4. Not in my humble submission are more than sufficient. Not for the London may not the special just to consider this application.
Where was the necessity for 164 recording after the
Not of course,
commencement
not
of the
the
trial?
heading of section 164 says not it could not have been
Statute,
recorded
sir,
after. That's what not. I'm not. I
up
have
to
read.
the trial.
I have read, my lord, I have read 64. Not if, not for any reason. Not the learned special judge, my lord, was not right in considering or may not directing recording of 164 statement and considering it. Not the material, not at page 100, not is well within his knowledge.
You should have passed an order on this. The entire order refers to only 164 statement.
Not entire order refers to the statement made by the prosecution.
What
But it is
statement?
they who is saying that my statement is based on the,
No,
not
which
164 statement.
statement, sir?
Kindly have a
Come
look
come
at,
to the
not-
impugned order, sir.
not the- exactly. not
Come
your
to the
lordship, kindly have
reasons.
a look at-
Reasons would commence at page 63.
Not your lordship, not page 70, 67, not is the
All right. 67.
67.
ಈ
not-
statements ಯಾರ್ದಿದು?
Not for instance, I have culled out the necessary, not your lordship will find.
Statements which are forthcoming in the additional
Additional
response which has
response
been
which have been
filed.
filed by the CBI authority which are as follows.
It's all right. That
But
is your
now-
additional response.
This is my additional response.
Where did you get that additional
Not
response?
in the letter, not at page 100. But your lordship may not kindly have a look at, the details were not found at page 100.
That is not a part of your objection also, but it is
This,
a
no, this
letter.
is, this is
That's all
part,
right.
not your lordship may kindly see,
All
on
right.
page 99, this part of my statement. my lord.
That's.
I am
that's all.
also enclosing a letter of the petitioner addressed to the incident case.
Sorry, Prasanna, for a second, kindly pardon me. I'm
Like this, sir.
interrupting you. Kindly go to
Ile-
page 109. This is the additional response. Page 109.
Yes, sir.
109 confession statement under 164.
Alala. Response of CBI and the application filed by the accused Baswaraj Muthagi.
Additional 105.
Move. 109.
109 is statement 164.
105.
105 to 108.
Okay.
105 to 108.
105.
Yes, 105.
I'm sorry, 105.
It looks like 9.
Yes, I'm sorry.
Yes.
ಎಲ್ಲಿದೆ?
No, additional response they see ಅವರು ಮಾಡಿರೋದು ಏನು ಅಂದ್ರೆ the said statement recorded on 164 so and so has disclosed the following crucial facts. They also rely on 164.
Not but the fact remains.
1 minute sir. ಈಗ ಅಲ್ಟಿಮೇಟ್ಲಿ ನೀವು ಏನ್ ಕಲ್ಔಟ್ ಮಾಡಿದೀರಾ ಅದು 164.
ಅಷ್ಟೇ.
ಕೋರ್ಟ್ ಏನ್ ಕಲ್ಔಟ್ ಮಾಡಿದ್ದಾರೆ ಅದು 164. ಕೋರ್ಟ್ ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಅದು 164. 164 is impermissible.
But otherwise, not even otherwise.
ಅಲ್ಲ even she could have passed the order on that.
Not my submission to lordship is not the application, the amendments made. The application at page 92 not clearly indicates the reason may not for him not to file the application under section 306. Coupled with the application, not the prosecution.
ಅದು ಏನಾದ್ರು ಮಾಡ್ಲಿ 164 ಕಳ್ಸೋದು ಯಾಕೆ ಬೇಕಾಗಿತ್ತು? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅದನ್ನೇ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಮಾಡಿ ಅದನ್ನೇ ಅಪ್ರೂವ್ ಟರ್ನಿಂಗ್ ಇಮ್ ಅಪ್ರೂವರ್ ಅಂಡರ್ 164. ವೇರ್ ಇಸ್ ದಿ
Not even if not the,
is it not going acting completely contrary to 164?
not even if not the.
Because 164 is a confession statement of a witness. Generally the complainant or witness, whatever it is. Confession statement of a witness, it stops at the stage of commencement of the trial. Over. ಆಮೇಲೆ evidence. 160, wow, going, putting the clock back to confession statement.
My submission is not the IO report or may not the statement may not made by the IO, the response of the IO to the second application, not also is may not accompanied by the letter of may not the accused number one.
Right, but why 164?
Not there is not in my humble submission, there is
No, you
absolutely
cannot say there is no bar.
there
a
is no
specific
difference.
bar.
I understand.
Yes.
There is no difference between the statement made by accused number one on page number 100 with not in comparison with the statement made under section 164.
ಎಲ್ಲ ಸರಿ ಇರ್ಬೋದು ಯಾಕೆ?
There is no difference.
ಅರೆ maybe sir,
Not whatever was within his knowledge, not he has stated.
it is on the face of it aberration of the statute. Where can, how can you come
No, now,
total,
not what has to be seen, at the stage of
No, no.
306 is.
at the stage of 306 ಅಲ್ಲ. Now 306 is completely based on 164 statement. That cannot.
No, my submission is not the application is not supported by the statement of accused. Not at
Application
page
ಮೇಲೆ
100.
ಬರೀಬೇಕಾಗಿತ್ತು. ಆ ಭಯ ಯಾಕೆ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಬರೆಯಕ್ಕೆ 164 ತಗೊಂಡ್ಬಿಟ್ರು ತಾವು ಮಾಡ್ಬಿಡೋಣ.
Not my submission is, even if may not, your lordship may not want to compare the statement under 164 and may not, the statement of the very accused, not page 100, it is one and the same. There is absolutely may not no difference. But all that the London magistrate or special judge will have to do, not is satisfy himself that he is going to state all the facts within his knowledge concerning himself and the other accused persons. Not that is the only scope so far as not 306 is concerned. But with the material available on record, not with the my not objection as well as not the statement of the accused. But in my humble submission, what was more than sufficient not to consider the application.
More than sufficient. Why is this?
Not for any reason. Not if one portion of the order not is bad, that doesn't mean not in my humble submission.
No.
The whole order not must go. If one of the finding not given by the learned special judge is based on inadmissible material, not that should not be not a reason.
No. See, in a procedure, in a process, for example, in a process of selection, you can't wash out the entire selection. You can weed out the illegality. In an order passed by a court, there is no question of weeding out the illegality there. It stays or it goes. That's unless it is justified.
Not my submission is not this. The statement of accused number one is very much on record. There is absolutely no difference from his statement at page 100 and may not one
But
section
will it
164
not
statement.
be directly contrary to 164?
Not even if he eschew not that part of the statement not of accused number one under 164, it is same not as his statement at second not page 100.
But let's see, the court should have passed the order on that. Let's see. We'll consider.
This is not on, not may not also bring to your lordship.
ಯಾವ್ದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ 164 ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ ಮಾಡ್ಬೋದು ಅಂತ?
ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ ಟ್ರಯಲ್ ವರ್ಗೂ ಅಂತಿದೆ. Not may not bring to your
That's
lordship.
what
kind
my lord, I
notice.
submitted unless and until my lord rules like that, which becomes the law. The statute prevails.
But on not the maintainability of this petition at the instance of
Maintainability at the instance of the
of the
co-accused.
co-accused, not I had brought to your lordship's kind notice. Not 2013 part 15 SCC page 322. Not
ಅಶೋಕ್ ಕುಮಾರ್ ಅಗರ್ವಾಲ್
other ಜೊತೆಗೆ not how that is how this is interpreted not by this honorable court, that also not I will bring to your lordship.
ಕೊಡಿ. ಯಾವ್ದು ಸೇಲ್ ಅಲ್ಲ?
ಅದಲ್ಲ ಇನ್ನೊಂದಿದೆ. This Ashok Kumar Agarwal not on the other day I read to your lordships, not para 40. ಕೊಟ್ಟಿದ್ದೀವಿ.
This is what I have considered in that.
Please, no,
Mallikarjun
this has been,
shipping.
no, your lordship not did not consider the maintainability.
Maintainability.
Maintainability. No,
I
this-
is not going to that.
This judgment not has been further.
Because
may not
there you
consider-
accepted that.
Please, this judgment has been further considered may not by this honorable court,
Pudi.
other coordinate bench.
Coordinate bench holds that it is not maintainable.
But it says you will have no right of audience. Not paragraph number 4. Is what may not the effects of the this honorable court would quote the judgment of Ashok Kumar Agarwal. Then not your lordship may kindly come to page 4, para 5. You are accepting the above such observation made by the apex court. The co-accused gets absolutely no right of audience before the court. The court can at most treat the petition filed by the petitioner without right of audience has so motor revision in order to examine the procedure irregularity or regularity, if any, committed by the court will grant it.
Hmm.
This is not the other
So
one.
some leeway is there for revisional jurisdiction.
Revisional
This is
jurisdiction.
inherent jurisdiction.
Inherent jurisdiction. You will have not absolutely no right of
Hmm.
audience, not on the judgment cited, but in Kailash Nath Agarwal's case,
Hmm.
not paragraph number 15.
Hmm.
Not, your lordship not was pleased to not observe.
Hmm.
will not find.
Yes,
Fresh application. Only fresh or additional. Paragraph number 15, not
Yes,
last
sir.
4 lines.
But why have you dragged the proceedings so much? Look at the order sheet.
Like maybe 1 or 2 days, will not
So
have.
1 or 2 days allowed.
Yes, throughout,
Why is this?
throughout I will
ಈಗ-
show you.
No, when you were wanting to say that they are.
No, no,
When-
my learned senior
dragging the
friend.
proceedings.
Not-
That's all right.
One ನಿಮಿಷ ಇರಿ, one ನಿಮಿಷ.
My lord has not stayed the trial. My lord only has said that he should not be examined. The rest of the witness court ಬಂದ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರನ್ನ ಆಚೆ ಕಳಿಸ್ಬಿಡೋದು ಹೊಟ್ಟೋಗು ಅಂತ ಅದನ್ನೇ ಬರ್ದಿರೋದು ಜಡ್ಜಿ.
ಇವರು ಇದನ್ನ ಹೇಳ್ತಾರೆ. Not when I ask, not ask the,
ನಾನ್ ಹೇಳೋದಲ್ಲ
ಪಾಪ.
order sheet ಹೇಳ್ತಾ ಇದೆ.
he says, accused themselves may not bring these witnesses.
It's all right, but court records against you.
That may not, that may not of finding, means 1 or 2 hearing dates, but may not
Throughout.
throughout illa sir.
That is what the learned judge has written. Throughout it is happening like that.
It's a
The head of the
it's
Bureau
a
of
matter of record.
Take immediate note of it.
No, that was.
Hello, why, when there is a direction to conclude the trial, why are you dragging it?
But I am not dragging it. Not the issue is, witnesses, not accused may not bring the witnesses to the court.
Why you don't have the capacity to bring the witness?
Like the capacity, I'm not this.
ಮತ್ತೆ accused ಕರ್ಕೊಂಬರ್ಬೇಕಾ witness ನ?
Provide security to the approver. Why should you not provide security to the witnesses and bring them?
ಅಂಡ್ ಇದು ಟ್ರಯಲ್ ಅಲ್ಲಿ ಹೆಂಗಾಗುತ್ತೆ ಅಂದ್ರೆ ಇವತ್ತು ಫಿಕ್ಸ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ ವಿಟ್ನೆಸ್ ಬಂದಿರಲ್ಲ ಕೋರ್ಟ್ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಯಾರೋ ಒಬ್ರನ್ನ ಕರ್ಕೊಂಡು ವಿಟ್ನೆಸ್
ಅಷ್ಟೇ.
ಅವತ್ತು ಅದಕ್ಕೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್
ಅಲ್ಲ
150 ವಿಟ್ನೆಸ್ ನಂಬರ್ 153 ಇಸ್ ಎಕ್ಸಾಮಿನ್ಡ್ ಎಲ್ಲಾರ ಮುಂಚೆ
ಹಳೆ ಕಾಲದಲ್ಲಿ ಇನ್ ಗುಡ್ ಹ್ಯೂಮರ್
ಇಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹತ್ರ ದೆನ್ ವಿ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಲೇಟೆಸ್ಟ್ ಅನ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಒಂದು ವಿಟ್ನೆಸ್ ಬಂದಿದ್ದೀರಾ
ಅಲ್ಲ ಹಳೆ
ದಿಸ್ ಇಸ್
ಕಾಲದಲ್ಲಿ
ವಾಟ್ ಹ್ಯಾಪನ್.
ಮೇಲಡ್ ಹಳೆ ಕಾಲದಲ್ಲಿ ಸೆಷನ್ ಜಡ್ಜಸ್ ಇನ್ ಗುಡ್ ಹ್ಯೂಮರ್ ವಾಟ್ ದೇ ಯೂಸ್ ಟು ಡೂ ಅಡ್ಜರ್ ಮಾಡಿ 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 ಬೇಜಾರಿಗೆ ಹೋಗ್ತಾ ಇತ್ತು. ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಇವತ್ತು ಯಾರಾದ್ರು ಬಂದಿದ್ದಾರೆ ಯಾರು ಬಂದ ನೀವೇ ಹತ್ಬಿಡ್ರಿ ಏನೋ ಮುಗಿಸ್ಬೋಣ.
Not one more may not about this petition. Not all the senior friends may not argue. The order is against me. I was not heard. I am a party to the proceedings.
ಯಾವ್ದ್ರಲ್ಲಿ
ಇದರಲ್ಲಿ ಇದನ್ನ ಮಾಡುವಾಗ by the trial by the London special judge while considering the application not of section 306. Now in this petition, not they have not arrayed my lord the person in whose favor the order is passed.
ಅವನ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು ಅದ್ರ ವಿಟ್ನೆಸ್ ಪಾರ್ಟಿ
ದೇರ್
ಮಾಡ್ಬೇಕು
ಆನ್
ಅಂತ.
ಪ್ರೊಸೀಜರ್.
ಮೇಲಡ್ he is an accused.
No, there is an order in his favor, not rightly or wrongly. But I can say
That
the
is
number
what
of
is
judgments on
question.
the point.
ಅಲ್ಲ
Rightly or wrongly,
you
no, there is an order.
argument versus argument you can make, but yes.
Please.
Yes, heard, deserved. Heard the ಎಲ್ಲ
ಅಲ್ಲ ಇಂಟರ್ ಮಾಡಬೇಕು
entry orders, in the light of the matter being heard and reserved, the interim order subsisting shall continue till the pronouncement of the judgment.
Please.
ಅದ್ರಲ್ಲಿ ಟ್ರಯಲ್ ಏನು ಸ್ಟೇ ಆಗಿಲ್ಲ.
ಇವ್ರದ್ ಮಾತ್ರ.
Not stay.
I have not stayed the trial.
My learned friend is, no, trial is being protracted. Who is protracting?
No, I guess I have not granted.
No, you
Lordship has
I have not
said, defer the recording of evidence of this approver ಅಷ್ಟೇ.
Defer the recording of evidence of accused number who is turned
Yeah.
approach. Trial will-
Trial is not stayed. Deeply obliged.
Yes,
Sorry, my lord, we have taken your lordship.
but that's all right, sir. Yes.
Grateful.
ಅದಕ್ಕೆ ಇವತ್ತೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಕೊಟ್ಟಿದ್ದು. You can take your time on.
But this is an interesting point of law.
ಇಲ್ಲ, all 4 matters are same,
Same order challenged by different accused.
same, all 4 reserved, all 4 reserved.
Please.
Got some interesting point of law. I wanted more time. That's
Yes, no problem, sir, no problem. Same, ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡು.